Welcome everybody. Is the sound clear? Good. Thanks everybody for coming. This is the predictive policing panel. In more detail, it is the panel called Digital Crime Control, the impact of predictive policing on democracy. And we're doing a bit experimental. We won't have PowerPoint slides because we think that you have seen enough slides at conferences already. So we're doing the experiment of diving directly into discussion. We hope it's entertaining. It might also lead to complete chaos, but then hopefully the chaos is entertaining. I'm a bit humbled and I think blushing a bit by all the impressive speakers around me. We have Miss Sheena Urwin here, who has practical experience with predictive policing, as she has worked at the police for a long time already. And then next to her we have Professor Ruggieri, Salvatore Ruggieri, who is a computer science professor at the University of Pisa and wrote one of the first papers in the field that has that is known nowadays as fairness in machine learning. So he basically wrote roughly 10 years ago one of the first papers that warned how machine learning, and nowadays many people say artificial intelligence, can discriminate by accident, which is obviously relevant for predictive policing, because you could roughly summarize predictive policing as something like using big data to predict crime. Then here we have Rosamunde van Brakel, an extreme workaholic, because she is the boss, the managing director of this whole conference. And apart from that, she also finds the time to be a leading voice in research on predictive policing. And she has, can I summarize your discipline as criminology? Yeah, very interdisciplinary.
Surveillance study.
Criminology with some sprinkles of surveillance studies. Then next we have Lucia Sommerer, also a specialized researcher, specialized in predictive policing, but mostly from a legal perspective, US law and German law. And this year, so she's based at the University of Göttingen, except this year, which you spent at Yale, right? And then we have Elise Lassus, who's a researcher at the Fundamental Rights Agency in Vienna. And one of her works is a big report on how to ensure that profiling doesn't lead to unfair or illegal discrimination. Then I'll make a brief remark on the topic itself, predictive policing. So you could see it as just one example of modern use of big data or machine learning, but some things, so at the core, the technology is very comparable, for instance, with behavioral advertising, but many of the moral and legal and policy questions are different. For instance, regarding false positives. So Google, we can have many panels on the online tracking, etc., by companies such as Google and Facebook, but false positives is usually not the major problem. Google keeps on serving me ads for shampoo and other hair products, but that is not the main issue. I have many questions around the data collection by Google, but yeah, false positives is not a big problem. But of course you wouldn't want to be the person that every time again gets picked out of the line at airports, or you wouldn't want a person who is wrongly questioned by the police, etc. So that's only one example of how predictive policing has different questions and different possible problems than the use of big data in general. And now we'll do a quick round of around the panel. Everybody can, if they want, mention, for instance, a topic that or a subtopic that I forget, or you can mention a question that you hope that we can focus on more. And at some point, roughly halfway in the panel, we'll ask the audience too if you have questions or remarks. But for the first 45 minutes or so, please remember your questions. Okay, we'll move to Sheena.
Good afternoon. Thank you very much for the invitation to come and speak today. I'm really keen to understand and hear the views of people in the room. I suppose that one of the reasons that I'm here is because we have an algorithmic risk assessment tool that we are using live in our custody suites across County Durham and Darlington, which is a police force in North East England. Before I get into talking about the harm assessment risk tool, I just want to take us back to what UK policing is. So in the UK, we police by consent. The public are the police and the police are the public. And it goes right back to 1829 to our Pelian principles. And I'm just going to read two of them out to you because I think it kind of sums up why I've come today to hear your views. So the first Pelian principle, it was developed to define an ethical police force. And the first principle is that police must prevent crime and disorder as an alternative to their repression by military force and severity of legal punishment. Now that's pretty key to the reason why we use the harm assessment risk tool, which I'll come to later. And then secondly, we need to recognise always that the power of the police to fulfil their functions and duties is dependent on public approval of their existence, actions and behaviour, and on their ability to secure and maintain public respect. For me, this is all about trust, it's all about transparency and openness. From a police point of view, we need to be as open and transparent as we can be when we're using these tools, but there will be occasions where we can't be as open and transparent as we would want to be. But where we can be, we should be. And in doing so, we will hopefully build trust. And that's why there's an awful lot of information out there in the public domain about the harm assessment risk tool that we have. It is a decision support tool, the harm assessment risk tool, and it assesses risk of reoffending. Decision support is nothing new for police officers, not just in the UK, but across the board, across Europe. Decision support isn't anything new. It starts from the minute police officers join the job. They receive training in the law, which helps them craft the decision-making, guidelines, protocols, procedures, policies, Information Commissioner guidelines, Independent Office of Police Conduct, Police and Crime Commissioner local priorities. I could go on. And in every single decision a police officer makes, we expect them to be perfect when they make that decision. So it's absolutely right that they have the very best decision support tools available, and that means experimenting, that means innovation, it means we must innovate, otherwise we stagnate, as long as we do so within a rigorous academic framework. That's what we've sought to do. We've worked with the University of Cambridge to develop the harm assessment risk tool, and it is supervised machine learning. And we've gone on to develop a legal ethical framework called Algo Care with the University of Winchester and the University of Sheffield. I don't want to take up all the time by talking too much because there are other panel members here, and I'm sure some of the other things that I have to say will probably be teased out with questions perhaps later on. But for me, like I said at the beginning there, it is all about trust because we police by consent. We must have the public's trust. But one thing's certain, using machine learning, using artificial intelligence within law enforcement and for the police, it's not going away, and we have to find a way to balance individual rights with the rights of community. Okay, thank you.
Okay, well, good afternoon everybody. I would like to take a position from computer science. Warning on the current state and pitfalls of the research so far. As Frederik mentioned, from a computer scientist or data analyst point of view, this field started growing about 10 years ago, and nowadays there are whole conference in parallel with this one about fairness, accountability, transparency, and ethics. But there is no clearly accepted definition of fairness. Just to give an example, last year there was a tutorial entitled 21 Definitions of Fairness, mathematical formalizations of what is a fair decision by an automatic system. And 21 was a lower bound. There are many, many more around. Also, what is difficult is to discover bias in automated system, just because they are very intricate, and bias can be in the data used to train the automated decision system, can be in the algorithm, can be in the process, can be in the wrong usage of a good decision support system used in the wrong place. Data. What about data? Machine learning process data to produce algorithms which learn from the data past decisions made by humans. But we as humans have a lot of biases. As psychologists tell us, we tend to simplify things, to remember only the most the things that most impressed us. And this bias is turned into the data and learned by the system. This is because, for instance, there were system learning to be racist online, or to associate certain jobs to men and women, and so on and so forth. Another problem with data and also algorithms is that in order to be fair, the algorithm should be trained with ground truth. For instance, we should tell the algorithm under which condition a person was recidive in committing a crime. But actually, we know the behavior of a person only when the person is released on parole, for instance, and we can observe the behavior of the person. If the person is kept in jail, these affect the future behavior, so we don't have a ground truth. There are tons of papers, scientific papers, that do the analysis of the COMPASS dataset, which is a famous dataset, American dataset, in which the observed pseudo ground truth is recidivism in the next 2 years. But this is an approximation of the real behavior that a person would have done. So my point here is that we should, as a community, a multidisciplinary community, we should strive to build some ground truth dataset, or gold standard dataset that can be used to evaluate and to test algorithm and automated decision making. Without this ground truth, the problem will be that algorithms will learn what previous humans have decided, and we replicate this bias.
Thank you very much, Salvatore. Then we continue with Rosamunde van Brakel. Say what you were planning to say, or react on the fact, because since Salvatore warned us of all the possible problems with predictive policing and data mining, I realized that there's at least one author, a law professor named Harcourt, who wrote a book against prediction, and his conclusion was we should stop using any type of predictive policing because the risks are too big. So that would be one approach, but I was wondering what panel members, well, I can imagine what Sheena would think of it, but
Okay, I will get back to your question, but I think it would be helpful because I don't think everyone in the audience is an expert in this topic, to give a bit more context to what predictive policing actually is. There are two types of predictive policing can be identified that are being implemented in Europe, in the US as well, but my research focuses on Europe. There is the mapping applications on the one hand, and then the identification applications on the other hand. So the first type of applications is a continuation of hotspot mapping from the 1990s, where the idea is that you predict which areas or neighborhoods, for example, in the case of burglaries, there's a higher likelihood that a burglary would take place. And because of this prediction, the police can put their patrols, they can make their patrol planning more efficient. The identification systems are more focused on individuals. It's often risk assessments which are behind them, and the idea is to identify, predict who will commit a crime. These, in Europe at least, these are more limited. Sheena in Durham, this is one of the examples of the identification systems. There are some other examples that I won't go into, but it's much more limited than the mapping systems. The mapping systems we can see in the Netherlands, the police developed the CAS system, they developed it themselves. In the UK, Kent police have been piloting Predpol, which is American software, for a long time. Actually, last year they decided to stop using it because they're not happy. In Germany, in some cities in Germany, and I'm sure Lucia will talk more about Germany, and in Switzerland they have Precops, which the police also developed themselves. And so that's kind of to give you a bit more context. Also, I want to emphasize, because my impression, and especially coming back to what you referred to, the fairness discussions, is that these discussions are often very ahistorical. They are, these systems are not new. The ideas behind the identification systems, you can see these risk factor research, prediction research within criminology is already from the 1940s and 50s. They have been doing this research. And a big issue, which Salvatore also mentioned, is the bias in the data that is put into the system, so the bias in the risk factors. A good example of this is a very famous piece of longitudinal research of Professor David Farrington from the 1970s, which is one of the most famous risk factor research, looking at risk factors of the likelihood that young people would commit crime in the future, or would be more prone to commit crime in the future. Now, this has been used more recently in the UK as a basis for systems to predict, to do risk profiling of children, while other researchers who have critically looked at this research found that the risk factors Farrington identified were based on a biased group of the group they used for their research was biased. Then I want to a second point, and then I'll stop. I want to raise the issue, and I'm hoping to hear Sheena's response to this. So at the moment, these systems are geared to more, identify, for example, where the burglaries will take place, or in parole decisions if someone is more likely a risk to commit another crime or not. I'm wondering, can we not use these systems in a more empowering way? Can we not use it, for example, the mapping systems, to map which areas need more community policing, for example? What I'm seeing is, for example, in the Netherlands and Belgium, where community policing was quite popular, is that the investments in community policing are being taken away and are being invested in these technologies. And I wonder why, because there is evidence that community policing is actually pretty effective. So
what is community policing?
Okay, so this is, Sheena can answer this better than me, but it's the idea is that the police is much more present in communities where there are issues, and they talk to people, and they gain more trust of the people in the communities. They ask them, what are your issues? Do you feel safe? That kind of thing. So that's in very simplistically.
Thank you very much, Rosamunde. That's indeed an important distinction between predicting in which street something might happen, or predicting if a certain person will do something. And also good that you point out that the history of predicting crime, etc., is much longer than the VUB conferences. We move to Lucia Sommerer.
Yes, thank you. And thank you for drawing out the context and the distinction. I think there's one more interesting distinction that we could make in individual level predictive policing, and that is that some systems are designed to generate a new suspect for the police, someone they didn't have on their radar before at all. This, for example, happens if we put all the data of all people in the city, for example, in Chicago, into an algorithm, and then they give us the highest risk score of the people most likely to commit a crime. We get new suspects. But predictive policing on an individual level can also be used to confirm an existing suspect, someone the police already has on their radar, maybe because they've been arrested, or because, like it is in Germany, because they are on the Islamist terrorist watch list. And then we can use the algorithm to confirm a suspicion here. And that could be an important distinction from a legal point of view to determine the threshold. When are we allowed to use it? What triggering event do we need to use it? And I would like to respond maybe to what Sheena has mentioned also, the fact that HEART is a decision support tool. And I think that is a very important decision, to make it a decision support tool and not just replace the human police officer's decision. However, I think it can also be a narrow line between a decision support tool and fully automated algorithmic decision making. And why I say that is a thin line possibly is because we have automation bias. It has been shown in studies that it is very difficult for humans to make a decision against the algorithm after they've given a number that has come out of this big black box that has a lot of authority. So this is why it may be a small difference between decision support and fully automated decision making. And one more distinction I would like to reply to, and you also mentioned that we could also use algorithms in a more positive way to help the community. And I think that is also true, but sometimes when we see that already in algorithms today, we often see the term risk need-based algorithm. For example, the bail algorithm Compass is risk need-based. And also HEART is also need-based in a way because it goes towards intervening and helping individuals with a medium risk score. And I think this distinction is important, but it could also in some cases just be a fig leaf, because if you're designing an algorithm to help people in need, the other side of the coin is that you're punishing people with that do not fit that need. For example, if you're designing an algorithm to release those that are not dangerous as early as possible. If you're designing it to help those to get out of jail as early as possible, you're punishing those with the highest score. So this are just two sides of one coin.
Thank you very much, Lucia. Then we continue with Elise.
Thank you very much. So thank you very much for all the speakers for making these very interesting first introductory remarks. I will just say a few words about what we have been doing on this topic at the EU Fundamental Rights Agency, so that to explain the point of view, the perspectives that we took on this. So indeed,
could you briefly say what the Fundamental Rights Agency is as well?
So we are one of the agencies of the European Union, and we are producing evidence-based analysis on fundamental rights. So the fundamental rights that are listed on the Charter of the Fundamental Rights of the European Union. But we do not only produce evidence-based advice. We have different type of products. We have reported. We look into the situation of the fundamental rights across the 28 member states, still 28 for now. We can produce legal opinions also on proposals by EU institutions, or the EU Commission mainly. And we also produce handbooks that can support experts in their work. So in this, we produce a handbook that is targeting law enforcement officers and border guards. That was recently published in December 2018. It's actually an update of a first handbook that we published in 2010, and that had a much narrower scope. So in this first handbook, we only covered law enforcement field. We only covered ethnic discriminatory profiling, and the introduction to data mining was very light. And it's actually the recent increase in the use of technological tools that pushed us in revising this handbook. So we, in this handbook, we cover unlawful profiling. So why unlawful profiling? Because it's not only discrimination based on ethnic origin that is covered, but on all protected grounds. So when you have an algorithm that is processing data, then there are risks to have discrimination not only based on the ethnic origin of the person, but on many other protected grounds that include disability, gender, age, religion, political views, etc., political opinions, etc. We also cover border management because border guards have been increasingly using large-scale databases, and these large-scale databases are being interoperable. So we have the interoperability between these large-scale databases. So this is why in this handbook we do not only refer to predictive policing, but to algorithmic profiling. So algorithmic profiling would cover both the predictive policing and the border management large-scale databases. So I won't enter into details about this. I just want to say two things. First of all, we tried in this book to be very clear and simple. So if there are experts on predictive policing, on profiling here, maybe it will be a bit simple. But the idea of this handbook is to explain to law enforcement officer what is unlawful profiling, why profiling should be lawful, and also in their point of view that it is in the interest of law enforcement officers to conduct lawful profiling, first because they would be held liable for it, but also because unlawful profiling can seriously impact on the effectiveness of policing itself. And finally, how to implement lawful profiling. So we give a toolbox, some principles on how to detect and avoid bias also, but maybe we can discuss this a little bit more in details during the conversation. Thank you very much.
Thank you so much. As is a tradition at privacy-related conferences, there's always a lot of possibilities to become very pessimistic. So we heard here risks of discrimination. It's the systems, predictive policing systems, cost money, which may be taken away from more traditional policing. There's nobody really mentioned it, but there's a quite obvious privacy risk, I would say, because predictive policing gives organizations, police at similar organization, an incentive to collect data. And for me, my intuition is if you hear about individual predictions, that doesn't really fit clearly with me with the classic idea of the presumption of innocence. So in all our societies, we agree that you shouldn't think that somebody is, well, you should always presume until proven otherwise that people are innocent. So perhaps that Mr. Harcourt had a smart approach, just forget about the whole idea, just ban it. We'll do another round from the panel. You can react on that or start a new subtopic. And after one round of the panel, then we'll ask for brief remarks from the audience. So you can, no, not remarks, only questions. So you can think of questions. And then also, in the meanwhile, you can think already how to make your question more concise.
Okay, just to pick up on a few of the points that you've just gone through and a few questions that were asked of me by other panel members. Just picking up on the neighbourhood policing, community policing that Rosamunde mentioned. Neighbourhood policing is absolutely important for policing. It's where we get our consent, it's where we get our trust. We need to have neighbourhood policing, we need to have community policing. In different forces in the UK, because of austerity measures, some forces have had to take the decision to withdraw those teams. Primarily that's so that they can continue to be an emergency service and respond to emergency calls. So essentially budget cuts and austerity measures have led to that decision making. In Durham Constabulary, we are fortunate that we still support neighbourhood policing. We very much see that the public are our eyes and ears. It's where we get an awful lot of our intelligence from, and it's how we do business. So I suppose it's right back to the Pelian principles again. So austerity did have some good sides to it, however. I think there was some fat in the system, shall we say, with policing, and it gave people a bit of a boost to start looking at and researching other areas of work to see if we could work more efficiently from a police service point of view. So there's been an awful lot more research done by UK police forces than there ever has been to look at evidence base. And I think a lot of that is down to austerity as we try to find new ways of working. So it was a good thing. However, if my chief constable was here for Durham Constabulary, he would say that whilst it has been a good thing, if we get further cuts, Durham may have to look at similar measures around community policing. But absolutely agree with you. It's what we need to have. In terms of decision support, it was mentioned there's a narrow line between decision support and automated decisions. And there was also suggestion around punishing people and putting people into custody or releasing them on bail. I think a really important point that I want to get across about the harm assessment risk tool in Durham Police is it does not decide if you are in custody or on bail. What it does is it contributes to the custody officer's decision making around an intervention for somebody, what we call a deferred prosecution. And we are testing through randomised control trial whether that decreases, reduces their reoffending or de-escalates the offending. We still have some time to go on that randomised control trial to be able to provide results for it. But I can say there are green shoots. I think what we need to remember with that is moderate risk offenders tend to be those kind of offenders who are stuck in the revolving door of criminal justice. We are building a case for trial, and we have another case coming in for the same person, whilst we're building another case for them. So clearly the punishment that's been received for those kind of more moderate risk offences isn't working. Is there another way? Is there a better way? And that's what we're testing within that randomised control trial. That's what the harm assessment risk tool contributes to. It's not about bail or custody. So I just wanted to make that real distinction around it. I don't think there was any other questions. Have I missed any other questions out? No. Just on the presumption of innocence, though, just a comment on it. Whilst I say deferred prosecution, the research programme is called Checkpoint. And moderate risk offenders, we have to have sufficient evidence to prosecute the offender. Only when there is sufficient evidence to prosecute the offender, and if they met other criteria, would Checkpoint then be offered, because it's a 4-month contract that you enter into, and if that contract isn't complied with, then the threat, the sword of Damocles is that we will then prosecute you. So we have to have that evidence before we can even offer the Checkpoint intervention. So in terms of the presumption of innocence, the evidence has to be there before we can do anything about it in terms of charge. But certainly the police don't decide guilt. The court would decide that.
Thank you. Then we move to Salvatore.
Thank you. I want to stress again and point out yet another risk is on people coding all the concepts that we have listened here, which are stated in natural language. Natural language is ambiguous. Computer science in general is an abstraction science. We, computer science, make an abstract model of the world. Then we code this abstract model into a program. I want to demystify AI. AI is nothing complex in principle, but the way that every single step is implemented is rather arbitrary, in my opinion. I will give an example in a moment. But the problem is when programmers code the concept that we have listened here, they have this abstract model in mind. They solve with a program what they think have understood of your context, and they claim they have solved your problem. And this is called solutionism. Which is wrong. They have solved their idea of what they think your problem is. And this happens not only in this context, in every context. Let me claim now the point of arbitrariness. The step in machine learning, for instance, very much rely on randomness, random number generation. We keep a subset of the data to train, for instance, a prediction model, and keep another subset to test if the model is correct. Okay? The way this selection, division into training and test is done is typically random. With some using some random number generation. In a recent paper, we studied what is the impact of this randomness, for instance, on explainability of the model. And unfortunately, the bad news is that current models, current predictive models, are very sensitive for what explainability is concerned with the way that numbers are randomly generated. So the point is, if the it is needed that a domain expert, in this case in predictive policing, with computer science coding their context, have to collaborate step by step to ensure accountability of the whole process. Otherwise, you run the risk to have tools that solve the abstract model that computer science have in mind.
Thank you very much, Salvatore. So it's very honest that you say that your discipline sometimes suffers from solutionism, solving self-invented problems. But I want to comfort you that in the legal field this happens a lot too. Many papers being published that solve a problem that you think, well, yeah, I guess it's a solution, but was there so much of it? So it's not only your discipline. We move to Rosamunde.
I want to pick up on your question in relation to Harcourt's argument about should we not give it up. Also in relation to this, a question is, can profiling not be discriminatory? Can we make profiling that it's not violating human rights? I'm not convinced. And in relation to this, another question, when these new technologies are being implemented, I don't get the feeling that there's ever an ethical discussion, do we really need it? So we're in several, so I indicated community policing, but also in other policy domains, there are best practices. Why invest money in a technology that you don't know will work, which has all these problems? I would like to know why. Yeah.
But is Harcourt right? Should we forget about the whole predictive idea?
No. I'm not sure he's completely right.
Okay.
But, yeah.
Thank you so much, Rosamunde. We continue with Lucia, then Elise, and then we take questions.
Yeah, I would like to comment on the presumption of innocence question and then add something to what Salvatore has said. First, to the presumption of innocence. When we have an algorithm that profiles people and gives them a high risk score, and based on that, then we have an intensifying of police surveillance of this person, for example, it's a natural urge to think about the presumption of innocence in that context. However, in a narrow legal sense, the presumption of innocence is something that only applies to the criminal trial and only applies to a criminal act that someone has committed in the past already. It usually doesn't look forward and covers suspicions for something someone might do in the future. So that's the narrow legal interpretation. We could, however, think if now, because more and more really impacting police work and negative legal consequences are moved into the preliminary stages of the crime, if the protections also have to move in the same direction of the preliminary stages of the crime, and if we may need something analogous to the presumption of innocence, which would be maybe a presumption of harmlessness. And we could implement it in that way that for the presumption of innocence, a consequence of that in the criminal trial is that we can only find someone guilty if we have a special standard of certainty that they're guilty, and that is beyond a reasonable doubt. This is something that flows directly from the presumption of innocence. And then we can ask the question, do we also need something, a certain level of certainty we have to hold someone harmless, to think that they're risky? Because right now, internationally, there is no set agreement on a level of percentage, like, oh, if you're 60%, if you're 70% likelihood of committing a crime, then we can put you on the risk list in the highest category, then we can police you more intensively. And a very, very strong example that we may need to discuss publicly what that level may be where we want to put someone on a list is that in the United States we have the Compass algorithm in bail decision, and there it is already enough to have an 8% likelihood of being arrested for a violent crime in the next 2 years to be put in the highest risk category and to be kept in jail pre-trial. So that is 8%, and that's at least worth having a discussion public, also in terms of democratic participation about this issue. And just one quick addition I want to add to that. Salvatore has very beautifully drawn out that there are many human steps involved in an algorithm and in machine learning. And I think that is sometimes getting a little bit, the focus is away from the human in the discussion, and that I think is a problem. Especially, it's impossible to avoid the big metaphor of the black box when you talk about algorithms. And it's a very powerful and important metaphor. It scares people and makes them aware of what's at stake, that they're losing control. However, I think this metaphor could also have a negative impact, because when you think about a black box, what do you imagine? You imagine something big and massive and immovable and impenetrable. What you do not imagine in that picture are usually humans. But there are a lot of human work going into the design of such an algorithm. It doesn't just like spring up out of thin air and then exists, but there is a lot of data selection, data cleaning, model training, parameter adjustments, and all of these are human discretionary decisions that are maybe also an option for a regulator to go in and try to impact the decision making.
Thank you very much, Lucia. Indeed, a very important point, that it are human decisions that lead to computer systems being used for predictive policing, and are human decisions that decide how the system works. And then we get to you. It's also, while we are discussing this, I'm from the Netherlands, and it suddenly, I remembered again that in the Netherlands, crime is going down all the time the past 20 years. So you could also say, perhaps, and I know more countries in Northern Western Europe where you could also say, actually, there's no need for new measures. We're doing so good. And it's not only policing, it just goes down and nobody really knows why. I mean, in Holland we continue to close down jails all the time because there's no people to fill them. So when you make policy decisions, that is also something to take into account, I guess. Then Elise, and then the crowd.
Thank you. And I want to say thank you to Lucia, because when you made this question about the presumption of innocence, that was actually exactly what I would have said. That the presumption of innocence, so it's a fundamental right. It is protected in the Charter. And you have a directive that member states were supposed to have transposed by April 2018. And if you look at what the directive is saying, is that presumption of innocence apply to both suspects or accused person of a crime that have been committed. So if no crime have been committed, if you want to predict that a crime is going to be committed, then strictly legally speaking, presumption of innocence would not apply.
Which directive?
2016, and I don't have the number in my head, sorry. But it's, it was adopted in 2016, and it was supposed to be transposed by on presumption of innocence. And but if you look into this directive, you will see what are the principles that law enforcement officers should respect to be in compliance with the presumption of innocence. There is the fact that they should not refer to the person as a person that is guilty. There is the fact that the burden of proof of proving that the person is guilty is on the prosecution. And there is the fact that the person has a right not to self-incriminate. So there is nothing preventing law enforcement officers in applying these principles during predictive policing, actually. So it's not because legally speaking it does not apply that the principles that are implied through the presumption of innocence should not be followed, because this is the same objective of not treating a person as a potentially guilty one. And maybe just very quickly, because Rosamunde was saying that she's not sure that predictive policing can be human rights compliant. That's profiling in general. So stop and search and predictive policing. So I want to be optimistic, and I want to say that every type of action can be at some point fundamental rights compliant, of course. I'm not saying it's not challenging, but we had another research a few years ago, maybe some of you have seen, it was on surveillance by intelligence services. In the course of this research we did, we also selected 7 member states in which we conducted interviews with experts, stakeholders, oversight bodies that are that have an impact on surveillance by intelligence services in a way or another. And one of the members of one of the oversight body at some point told us, if there is a technique outside, it will be used. So I found this to be very powerful. If there is a possibility to use some kind of technique, it will be used by law enforcement or by intelligence services. So we need to find the ways to make these fundamental rights compliant. So it has to have a legal basis, it needs to have appropriate safeguards, it needs to be appropriately tested, it needs to have independent oversights, etc. So you have a set of different measures that can be implemented in order to make a technique fundamental rights compliant.
Thank you so much. That's quite a controversial conclusion, that if there's a technology, they will use it, and we can only regulate it after the fact. But panel members can react to that later. First, the audience has a chance. I see, I can't take all the questions, but I see 5. Okay, super quick, everybody, please. We'll take 5 in a row, and then we'll return to the audience. How much time do we have left?
Hi, Valerie Steves, Department of Criminology at University of Ottawa. I'll talk fast. Hi. I want to pick up on actually my question is for Sheena. I want to pick up what you were saying, Lucia, about human practice. So I've been doing some field work in regard to Canadian situation tables, which use similar risk assessment algorithms as you are, Sheena. And I was sitting in a room where the police and the city services and community organizers were discussing the risk assessment. And it went like this. The police said, we want to call this guy high risk because we're sick of him calling us. We're overworked, we don't have enough staff. We want him to call you instead of us because we just had enough of him. And then the community workers, grassroots workers said, that's ridiculous. He's no more high risk than anybody else. And then the city workers said, yeah, but if you label him high risk, I can get you some money for him. So they sat and they said, okay, we all agree he's high risk, and they randomly checked boxes. So my question for you is, what strategies have you developed in your police service to deal with the fact that human beings are going to create workarounds, these systems, and the data within the system will be guaranteed to have false information, and that as you match that data with other data sets, we know from information studies that the consequences of having false information in it will just rise exponentially.
Thank you very much.
Thank you. Charles Rabb, University of Edinburgh. I want to say something else about where I'm coming from on this question, but it's particularly possibly for Rosamunde and also for Sheena. I'm the co-chair of something called IDEP, which Sheena might have heard of perhaps, the Independent Digital Ethics Panel for Policing in the UK. And we were asked to do an ethical advisory report to the West Midlands Police Force and their consortium, which were putting in a proposal for funding of a predictive policing system. And Rosamunde said, do we ever get ethical kinds of things, analysis going? Well, this came sometime after they had drafted their application, and we gave an ethical advisory report. To cut the story short, Frederik, That report is available online. You can see it. But one of the controversial things in it was where we said, and I was responsible largely for drafting this thing on behalf of IDEP and the Alan Turing Institute, was that it looked as though some of the arguments in favor of the predictive policing stretched over into areas of social work and other kinds of social services, where if you could predict or think you can predict who is going to be at risk of committing a crime, you can intervene in social services sort of way. And we thought this was perhaps stretching the boundary of policing. And the West Midlands Police thought that it was always part of their service to do this kind of quasi-social work. And my question about this is whether there is the basis in legitimacy and also the effectiveness of the police moving in what we would argue would be somewhat out of its traditional zone of preventing crime and catching offenders. So that's my question. Is there a legitimate basis for moving into that area?
Thank you very much. Yes, indeed, those three hands that are still, yeah.
Hi there, Martin Lopatka. I work at Mozilla. In the context of predictive policing, all the varieties that have been discussed, carried out by systems, as Salvatore eloquently described. My question is if any of the panelists would like to comment on the possibility for these systems, these deterministic systems, actually being leveraged by organized crime. Is there the possibility that this is actually generating a vulnerability such that these kind of systems can be reverse engineered and exploited? Thank you.
Thank you so much. About gaming the system. 2 more questions and then we go back to the...
Michele Lui, University of Zurich. So, taking for granted that the algorithm has a lot of the human problems and biases, and also that maybe we will never agree on what fairness for prediction is to the level of precision we need to code it into an algorithm. Still, if you can have a predictive system that releases many more people out of prison, and at the same time, these people released out of prison on parole, let's say, make the same amount of crime. So you have more people out and the same amount of crime. I think then there is a utilitarian ethical case for that algorithm that maybe could override the more, the fairness, even the fairness problem. Maybe we are not releasing exactly the right people that deserve to be out, but in that situation, there's an ethical argument for it. Yeah. So I'd like you to discuss that.
Very good point. And then I'm going to misuse my position here. Yeah, you could also add, imagine that an algorithm is discriminatory on the basis of skin color in 10% of the cases, but that the human police force is discriminatory unconsciously, for instance, in 15% of the cases. You could make an argument that therefore the wrongly discriminating racist algorithm is still preferable over a racist human police force. And racist is perhaps too loaded. A police force that unconsciously is led by biases. I'm struggling with that myself. Okay, next question, and then we'll go back to the panel in the traditional order.
Hi, I'm Megan Goulding. I work for Liberty, over here, Sheena. I work for Liberty, the UK human rights organisation. I'm afraid, Sheena, you're popular tonight. My question is also for you. It's about explainability, which I think is a really crucial element, well described by Salvatore. And my question is, if someone wants to challenge the decision made about them through heart and the risk that they've been assigned, how do you explain to them the algorithm? How detailed do you get? Because of course, for legal rights to mean anything, we have to be able to understand how a public body has come to the decision that it's come to.
Thank you so much. It's clear that we could easily do a whole conference on predictive policing, but in real life we have 15 minutes left for the panel, and we'll do the whole panel in a row. I'll quit talking, but panel members, please remember the time limit.
Okay, very quickly, so the rest of the panel have got an opportunity to. In terms of high risk and whether it influences funding, I can only speak from Durham Constabulary's point of view and say that high risk category, when it is given to the custody officer, and it is only the custody officers that have received training on it, not the whole force. When it is given to the custody officer, that's the only time it is used to contribute to their decision making. So it is not used as part of the court process. It is not used in any partnership environment in terms of funding. So hopefully that answers your question in relation to the harm assessment risk tool. In terms of the basis of legitimacy for straying into potential social services area, what I would say is I think going forward, these kinds of tools are already starting to be explored. You will know about that yourself from the report that you've looked at with the panel that you sit on. They're already being explored in multi-agency arena. I think one of the difficulties we have around legitimacy with that is the police service is the service of last resort. It is 24/7 and it's on call. So invariably when austerity hits and other services are cut, if there is no other service available, the police service is the service of last resort. And that then means if we've got repeat callers, if we've got people who are victims one day and offenders the next because of the vulnerability around those individuals, that's when it starts to stray into that social services area. And if we sit back and wait for another agency to do something and don't try and have those conversations with the partner, well, we're just going to sit back and twiddle our thumbs and do nothing and let it get worse. So we have to start to have those conversations with partner agencies. So in terms of legitimacy, I think we have to act because they could be a victim, not just an offender. Low risk, right, so the next question was about organised criminality and exploitation. In relation to the harm assessment risk tool, what I would say is before we went live with it, when we were testing it, we did find, for example, what we would call a principal OCG member come through the custody environment and was deemed to be low risk. That was the risk assessment, the harm assessment risk tool gave them. Because being the principal of the OCG, of the organised crime group, they got people further down the chain to do the work for them. And so if someone was caught, it was generally someone further down the chain. So the sort of predictive variables used in the model meant that it was coming back low risk. So in terms of is there an opportunity for them to exploit it, just in practical terms, I suppose, I would say custody officers have to understand the limitations of these models. Our model is purely based on Durham data. It's another reason why it can never be an automated decision-making tool. It is not linked up to national systems. Explainability in terms of challenging the decision. We haven't had anybody challenge the risk assessment, and I deliberately say the word risk assessment as opposed to the decision that's been made by Heart, because Heart doesn't make any decisions. Heart is decision support. And it's absolutely critical that we understand that it's decision support. The custody environment in the UK is heavily regulated by various legislation. The Bail Act 76, Policing and Crime Act 2018, and we've got Management of Police Information as well. So it's a heavily regulated environment. Custody officers have to explain the rationale behind their decision making, particularly if it's going through the court system. When we've reached that point of prosecution or going to the Crown Prosecution Service, they have to explain their rationale behind the decision making, because it isn't just the risk that the harm assessment risk tool gives that they have to take into account. There are other factors too. Okay.
Thank you so much.
Okay, would you like to answer a couple of questions? first on the theoretical side, is it possible that somebody act strategically against an automated system? Yes. But fortunately, this situation has been considered by computer scientists who have proposed variants of machine learning tools that use game theory in order to act against this strategic thinking on the theoretical side. Is it possible that an organization try and globally understand from, for instance, from explanation of single cases, the overall logic of an automated system? Yes, this is also possible. There is a recent paper that, given single explanation of decision, is able to reconstruct almost with high fidelity the global model making a decision. But again, fortunately, there are studies which bring together fairness and privacy in order to build models which are fair and maybe can give single explanations, but from this single explanation, like in privacy preserving data mining, it is not possible to reconstruct the whole global logic. This second part is less explored, but there are a few proposals. Okay, this is the theoretical side. On the practical side, all these are speculations, in the sense that there is no data set that can support really this kind. For this reason, the aim of the community should be in collaborating, building this gold standard for validating such technical proposals.
Thank you very much, Salvatore. We continue with Rosamunde.
Okay, I would like to respond to Charles's questions. I should the first response is I'm coming, or my background is mostly looking at Belgium and the Netherlands. And I've also been looking at other countries, and what I've been seeing with specifically predictive policing is that local police forces are doing pilot projects, and there is no panel. I don't think the panel you sit on in the UK exists in Belgium. Something similar doesn't exist. I don't think it exists in the Netherlands. So I see it's local police forces are piloting and going on with their thing, and they're not getting any expertise or ethical reflection from any committees. So I think there's a big lack there in the policy in several countries. There needs to be an independent board, at least considering, the issues. Concerning the legitimacy question, I think in several cases it is legitimate because there's a urgency and someone has to do something. But I also think that in cases, for example, when it is there are issues with someone with mental health problems, and the police are absolutely not trained to deal with people with mental health issues, or for example, people with autism, it can only actually make things worse because they don't know how to approach it. Now, I would advocate that police should have that role. They should not just have a repressive role, but the police training needs to be changed to accommodate it. So that's all.
Thank you so much. And we immediately go to Lucia.
Just briefly about the fact that the police are now also moving towards predicting not necessarily crime unrelated events like related to mental health or maybe related to child welfare. I think that is an example of a concerning function creep that happens once a technology is introduced into society or into the police. At first, it may be introduced for a very narrow set of circumstances. For example, in Germany, we see these kind of technology primarily introduced for persecuting terrorist activity and terrorist crime. But slowly, over the time, if the technology turns out to be successful or helpful, or the police think it's expanded to more and more other kinds of crimes, to organized crimes in general, and then to severe crimes, and then to all kinds of crimes, and eventually towards maybe even just predicting social undesirable behavior. So that's just the function creep. And to the issue whether someone could turn the algorithm against the police, I do not have data on that, but I want to throw in another idea that these algorithms can also be used systematically to monitor the police. For example, Sharad Girl of the University of Stanford has developed an algorithm, machine learning, that can predict police misconduct in citizen interaction in a predictive manner. So that is also an option how we can use it.
Thank you very much. I would like to react just one note about the question on the utilitarian of this, and just to say one thing, that predictive policing is about detecting potential individuals that would act unlawfully, but also potential victims. And I think it's in Chicago, Kansas, and I have a doubt, or maybe in both actually, that this list, they were using a calculation with points, and the higher the points, I think it was on 500, the higher the probability to be either committing a violent crime or to be a victim. And this happened to be sadly quite true for some of them. There were, I think, a couple of young men that were killed a few days after being selected by this program to be one of the highest probability to be either a victim or a person that would commit a crime. So that could be also another good aspect. And then very, very briefly, there were two questions that I think it's a little bit related. The one on the fact that individuals, they can actually request also access to the data and rectification of their data, and in that way they could also change the data, they could lie about it. And we had a question this morning on a panel on data quality where the person was asking, how can you trust that actually the individuals will give accurate data about themselves? And there were another question on the explainability. And we surprisingly never mentioned the law enforcement directive, but in the law enforcement directive, so as you know, that has to be transposed in every member state, there are some positive developments for fundamental rights. So data subjects are being empowered in their rights. The accountability mechanisms is also stronger. And regarding the right to explanation, I think there is a debate going on because it's only mentioned in the recital. But if you take the Article 11 on automated decision making, there is an obligation for a human intervention. And well, some experts say that this could also cover a right to explanation. And that's it.
Thank you so much. That leaves us to thank the audience for coming and for your great questions, and to thank all the panel members. And it's clear that there's many open questions, which is scary news for society and good news for researchers. Thank you very much.